everyone to Intellectual Property Strategy as a Business Strategy. My name is Paula Whittigand. I'm the Professional Development and Training Workshop Manager for the Arizona Network Small Business Development Centers. Joining me today is Esmeralda Estrada. She's our program coordinator from the state office. She's going to be helping to man our chat and questions. And of course, also welcome to our speakers, Gautam from the USPTO and Janelle. You'll be meeting them in just a minute as we start our program. All right, just as a reminder, please enter any questions you have in the Q&A. And like I said, Esmeralda will be manning the Q&A and chat for us. And we will also be recording the session today. It will be available up on our YouTube channel probably by the end of the week. All right, let's get started. Before I turn it over to our guest speakers, I just wanted to do a very brief introduction about the Small Business Development Center. Some of you may already be clients with the SBDC, some may be new and have not heard about us. But the SBDC is, we provide confidential one-on-one counseling for no fee to small businesses in any industry of any size. So whether you have an idea, or maybe you've started, you've opened your doors and need some direction about what do I do now, maybe you're starting to really scale up, or you're an established small business that really still needs some support for growth, SBDC is here to help you. And you see on the screen here just a wide range of expertise that we provide to our clients. Sources of capital, loan assistance, financial education, knowing your numbers is so important. Marketing, we have experts in export here in Arizona that can help if you're thinking or are already exporting. Government contracting through the Apex group, veterans assistance, and so on, and even special programs like our Advancing Entrepreneurs Ready for Opportunities program. You can find, we have the link there on the screen. You can always explore more after our session today, and we hope you do. For those joining us outside of Arizona, the SBDC is a national network. So you find us, there's 63 locations. You'll find us in every state, multiple locations in every state. So please reach out to your local SBDC. It's a quick little Google search, and there will be some resources close to where you live that can help you and your small business. So with that, I would like to introduce Gautam Ubale from the United States Patent and Trade Office. He's a primary patent examiner. He's going to kick us off today, going through different types of IP, talking about the importance of protecting your IP, and then we'll be sharing resources for you. Janelle Breedveld from the State of Arizona Research Library will be here to share those resources. You know, we have resources from the USPTO, but we also have some great local resources available as well to help small businesses. So with that, Gautam, I would like to turn it over to you. I'll stop sharing my screen and give you the floor.
Hello, good morning, everyone. I hope everybody can hear me well.
Yes, we can.
Okay, perfect. So thank you all for joining today's presentation on intellectual property strategy as a business strategy. My name is Gautam Ubale. I'm a primary patent examiner in business method 3682, and I'm currently working with outreach team at the Silicon Valley regional office here. Today, we'll go over some of the IP strategies that can help your business goals to achieve and take advantage of this IP property. So this is just a disclaimer that we want to put forward, that all the materials that we present today is only for informational purposes only. They are not legal advice. You must consult with appropriate sources for legal authority and guidance if you have any legal questions relating to this presentation. So this one is historical foundation of intellectual property, which basically is deeply rooted in our nation's history, and it allows an act to promote the progress of useful arts by securing for limited times to author and inventors the exclusive right to their respective writings and discovery. And obviously this clause was set up in somewhere early around 1700. And so here's the benefit of that I can go over the IP, which is intellectual property industries, intensive industries versus non-IP industries. So basically IP intellectual industries, you can see from the left side of the column that people tend to earn more income. They tend to hire more employees. They give better health coverages, and obviously hire more college graduates here. And this data was pulled from the 2019 edition US economy. And this is another identity indicator that shows how intellectual property intensive industries can add value to the US economy. This study has found that intellectual property intensive industries basically have created almost 63 million jobs, or 44% of our US jobs in IP intensive industries. You can also see the numbers, some repetitive numbers from the previous slide. And this data you can find at the USPTO's Gov website, as shown in this slide here. So how does the intellectual property important to your business strategy, right? So here are the 5 bullet points that basically gives you an idea. When you have an idea and you want to protect it, and you want to acquire some kind of investment or something, I think this is the best way to attract investors, like venture capitalistic. So I think you guys must have familiar with the CNBC TV show called Shark Tank. People have gone there to pitch their ideas. The idea behind that is basically the first question they will ask you is, do you own intellectual property? And when you do, that's when all those sharks, they basically get interested into your product or services that you are offering. So it's a great way to attract investors. It also is a good way to deter other companies from similar invention that was filed later than your invention filing date. It also gives you a property right by adding a value to your company that eventually allows you to sell or license it out. And again, you will have also an edge to gain an entry into global market. Again, this is territorial based on which countries you file your application at. So here I'm gonna, I'll talk about this, how to go about and develop the intellectual property strategy here, right? So first, we need to identify and access your company's intellectual property asset. Once you do so, you start knowing what your competitions are and understanding your technology and competitors within that space. So also, we'll weigh in to understand the pace of the innovation and the potential growth prospect. And so once you determine those 3 steps, initial C steps, we will try to determine how to protect your IP based on kind of asset. Is it a patent? That can be an utility, design, or a plant. Or is it a trademark or a service mark? Is it a copyright or trade secret? So once you identify what IP you possess, we can now start strategizing and developing and implementing the idea. And during that process, you can always seek help through USPTO by visiting the website or calling the IAC. But before we jump to the next slide, I'm going to have Esmeralda put a poll of what kind of industries you guys are in and what kind of IP you guys are interested in. So we will have 2 poll questions. We'll go over it right now. Esmeralda, do you want to? Yep, there you go.
Yeah, so posted the business industry one, and then once we get responses on that, we could go over to the next one. In the meanwhile, we have a question in the chat. What do you mean by intellectual property intensive industries? Can you give us examples?
So basically, when we say intensive industry, just let's think about Apple, right? Apple is a company. They have several patents. They have several trademarks. They have service marks. Means you must have seen logos of, TM, SM around their products. You have seen copyrighted products also from them, like their technical disclosure. And I think we'll dive into it more deeper once we start targeting each sections. Hope that kind of gives you some overview of what you were asking in terms of.
Thank you. I'll end the poll now.
Great. Thanks, Esmeralda. So we have a lot of manufacturing, retail, pretty. So construction and agriculture is almost minimalist. Okay, great. That's great.
All right, and then I will stop sharing and I will launch that intellectual property poll.
Yeah, because this is, okay, perfect.
In the meanwhile, there's another question. If I started my own business and I know nothing about IP, how can I figure out if I own my IP?
So it is perfect. After this slide, you're going to see a tool that USPTO has launched, and that's going to help you at least get to know what kind of IP I possess. And once we, kind of answer through this second poll, we're going to jump into that and hope that answers your question too.
Thank you. I will launch the results now.
Okay, so I'm new to intellectual property. We got 50% of people pretty new. There are some who have filed for patent, great, and process of filing trademarks, great, and others. Okay, so we got pretty good 70% people.
And Gautam, before you continue, just a reminder, if you have questions, please put them in the Q&A rather than the chat, and we'll keep an eye on that Q&A.
Perfect, thanks. So here's the IP identifier tool that USPTO launched, and I'm gonna quickly show you how to get there. So this is a great tool that will help you guys what kind of IP you can go for or apply for. So once you type USPTO, I'm hoping you guys can see this webpage, correct? Just thumbs up or anything.
We can see it.
Okay, perfect. So if you go on uspto.gov, all you have to do is click on this third link, identify what kind of IP you have. And once you do so, it will start with the basic identifier questions where you can read through this. And just like we had almost 48% people saying that we don't know what IP type I have, or they have no idea. So let's go with this question. And then we have questions. Do you use a brand name, slogan, logo, or any distinguishing yourself, your business from your competitors? We will say yes, we have something. We had people from trademarks applying for trademarks. Did we invent or design something like machine? We'll say yes, because we had people who filed for patents. Then did you design or create a computer hardware or software? I'll say no for here, but softwares created for Facebook algorithms, those are all softwares. Then did you design or create an artistic or literary work? We'll say yes for this just to see. And then do we have a secret formula or recipe? I'll just say no right now. And then, so do you develop any new plant or seed varieties? We'll say no here too. And and we'll see review responses. So once you verify your responses here, we can view the results, and this will check mark everything that you can do with what you answered initially. So you could copyright that, you could trademark it, you can do a design patent, and you can also do a utility patent. You couldn't do trade secrets and plant patents. And also there is a advanced IP identifier where you can dive into more deeper on questions, but you guys can play around with this tool to figure this out. But going back, so we wanted to basically expose you guys to this tool so you guys know how to approach this for people who are new. And so let's dive into what kind of intellectual property I need and how do I secure the legal rights. So we recommend that you secure your legal rights and the names that you see up here, like patents, trademarks, copyright, trade secrets, right? So we'll talk about patent here a little bit. It is basically protecting an invention. In a simple term, it is an exclusive right granted for an invention, which is a product or a process that provides, in general, a new way of doing something or offers a new technical solution to a problem. Then we have is trademark or service mark. This gives the legal protection for a brand. So think about a brand names like logos, slogan, things like that, which we use every day as a consumer to identify products. And then we have copyrights. So copyright is also a legal protection. As you can see here, it's an original artistic or literary creation. So we are talking about songs, movies, paintings, software, and so on. You can only sort of protect the expression of that idea once you affix it in a medium that is a tangible form that you're creating a copyright then. And the last thing is trade secret, which protects information that has value because nobody knows that. So basically, the word trade secret is just that information is kept secret. That's it. It's not known to the public. So trademarks. So what is trademarks or service mark, right? Anytime you see or hear a particular trademark, it automatically calls to mind a particular set of goods or services, or easiest way to really identify goods or services. So again, as I mentioned, think about brand names like logos, slogans, words, phrases, anything that can be identified as a source of a product, aka goods or services. They have trademarks like you see here. So trademark is how we distinguish products or services from one another. So here are the perfect example I often like to use. If I say the word BMW, what do you guys think of? Cars, right? If I say McDonald's, what do you guys think of? Hamburgers. When I say Coca-Cola, we think of soft drinks. So it is basically you are distinguishing your products or services from your competitors. And you will also notice service mark, which is the SM symbol. That is totally fine too, as it also refers to trademark. So, and the other thing about the service mark is it is used to indicate basically the source of your service. And that's, and you can just use the word trademark for that too. And so here is the best global brand evaluation that was performed by a private company called Interbrands. And they basically use their proprietary algorithm based on companies' economic profits and the role of the brand in making purchasing decisions and their brand strength against their competitors. So you could see here the most valuable brand is the Apple with $482,000 million brand evaluation here. and then goes on with Microsoft, Amazon, and Intel, which is pretty dominant in the Phoenix area also, right? And so let's talk about trademark rights and how they were created, because they really created in two ways. One is through common law and one is through federal registration rights. So common law, right, which essentially means that as soon as you start to use something that has your trademark to indicate the source of your goods or services, you're creating a trademark rights. So now typically this is done under state law. So whatever happens to be, there is probably a law on books or court case that says this is true, that you were creating rights under common law. Only issue is that your rights are limited to geographic area in which the trademark is used. So example, let's say you have a food truck and that is operating within Phoenix, Arizona area, and you have never advertised anywhere else. Then your rights are really going to be just there in the Phoenix area. And trademarks that is used in commerce in connection with specific goods and services, but not registered, okay? And US is the first to use country. So, and apart from US, most countries are first to file. So let's say you wanted to expand now your food truck business outside the Phoenix or state of Arizona, and you wanted to make sure that you have protection for your trademark rights, right? So you have to find a way to protect yourself nationwide. And this is when you federally register your trademark service mark here at USPTO. So the advantages of registering is it will help protect your brand on a nationwide basis. It will provide a public notice of claim of ownership. It will also provide you with legal and exclusive right to use the mark in US associated with goods and services nationwide, and gives you ability to bring an action in federal court. You also have right to use the federal registration symbol R to prevent others from using and expand your business across state lines. Your trademark also gets listed in the USPTO's online database, and also you can record your registration with US and Custom Border Protection, which is really great if you are operating in an industry where there's a lot of infringing products, basically. So trademarks, they can also be words such as Starbucks, Nike, or Target, right? And it also can be a design logo, just like the two-tailed mermaid for Starbucks, the swoosh logo for Nike, and a bullseye for Target. And they also can be a color. So like the Tiffany blue for boxes, that are used for jewelry products, or the famous brown colored truck identified as a UPS truck, and the John Deere equipment green and yellow color scheme that's used in that. And trademark also can be smell that we associate with scents, right? So example would be the Manhattan's oil that is used in engine lubricant. Basically, it gives out the exhaust smell for strawberry, grape, cherry, whatever scent they manufacture in that. Then we have the Verizon store, which is a retail store, basically uses a flowery musk scent to feature their communication products and services. And then we have the Hasbro's trademark for Play-Doh for signature scent, which has a combined smell of sweet, musky, vanilla fragrance in that. And all of this above scents have US registration number associated with it. And then we also have sounds. This can be trademarked too. So the Pillsbury Doughboy giggle sound, or the NBC chimes, the Nintendo's trademark for Mario coin sound, and obviously we know Aflac, that duck sound for insurance companies. And we also have the MGM signature lion's roar that you must have seen. previously. So what is trade dress, right? Again, they are incredibly similar because they are really doing the same thing as trademark. They are identifying somebody as a source of good or product, and that is based upon the commercial look and feel of that thing. So here you see some examples of trade dress, right? We have a shoe up here, which if I look at it, I know it's Doc Martens because this has that distinctive feature such as yellow stitching in the welt area of the sole. You have the two-tone groove sole edges, and then distinctive DMS sole pattern and a fabric, black fabric heel loop, right? Then we also have the interior design of this Apple store that has a trade dress registration for its unique store design. Then we also have, let's think about the bottle shape in that's made in a particular way. And typically, when you see this bottle from far away, you can see the look and feel of it, and you know it's Coca-Cola, right? So the trade dress is being used as a trademark to indicate basically the source of those particular goods. It is basically a non-functional, and it is not necessary to have any function on that because we associate that distinctive feature that it presents to us.
Gautam, we have several questions. Would this be a good point to take
Sure.
a couple on trademarks?
Sure.
All right.
All right. Hopefully you can all hear me a little bit better.
Yes.
Yes,
See you.
that's good,
Okay,
Esmeralda.
perfect.
Thank you. Mhm.
All right, sounds good. So I'll read a few of the questions out loud to you. So I run a skilled trade training business. How do I determine what is IP in a training context?
IP in a training contract. So can you repeat that question again?
I run a skilled trade training business. How do I determine what is IP in a training context?
So I think there are several ways you can, if you're writing some kind of a procedure, you could copyright it in a very distinctive way. I think you can copyright it. I'm not sure how can you trademark it unless, as I showed you some examples, or unless you come up with a logo or some kind of a slogan or words for that, trade skills that you're trying to create.
All right, thank you. So the next question, at what point should I trademark my logo, et cetera, if I am selling services, consulting services, food services, advisory services, professional services, et cetera?
So I think, as I mentioned before, that once you start using it, you already have the common law protects you, but now you want to federally register to expand it global within the nationwide. It's a good idea to basically register within the USPTO, and we're gonna talk in the next slide about the fees for this. The other great avenue to know in depth about this trademarks is we have a boot camp that started just yesterday that Jason Lott teaches, and it's an amazing boot camp for people who really want to know in depth about trademarks. It's an 8-part series. It goes for almost a quarter. So it's April, May, June. Every quarter we refresh them. And if they miss the first one, they can again join that the following quarter after July. But I would highly encourage them to, enroll for that event. And that's there in my last slide too, what events are upcoming, so they can look into it.
All right, so the next one, once I have a trade secret finalized, can I change it without having to file a new one? If I have a recipe and I end up tweaking it later on?
So we're gonna get to trade secret. We haven't talked about trade secret yet. And there is no federal agency where you can file trade secrets. So we'll talk about it a little bit.
Okay, I'll ask a few more questions and then we'll let you continue.
Okay.
So the next one, do you have to file separately for trademarks as words or symbols for the same company?
So trademarks here, I'm gonna open the next slide, which talks about trademark fees here, right? So depends on the class. So each per class, you can file for that goods and services. So now here I'm gonna quickly run over this slide. So you may, hopefully that will answer this person's question. So here we have two fees options. One is option 1, which is T's plus, and option 2, T standard. And they have initial fees of $250 and $350. So if you have two classes of goods, then you're gonna basically pay for each class. So let's say if you go with T's plus option, you will pay $250 plus $250. That's $500 for two different trademarks based on the classes of goods or services that you are providing. T's plus, T standard, it's again $350 plus $350. The difference between those two is basically, let's say if you already know your well, let me step back. If you don't know your class, what class the goods and services fall under, a lot of times people will file with the T standard, where USPTO has to use their resources to identify what class it will fall under. Versus the T's plus, we already have an ID manual in the USPTO's trademark database where you can pre-select that, and that's the best economical way to file for your trademarks. Again, number of marks, only one mark may be filed per application, right? Number of classes, you can have each class of goods or services in the application. You could have multiple classes in that application and pay, as I said, per class, $250 or $350. Hope that kind of gives some insight about it.
Keep those questions coming. And then Gautam, let's go ahead and continue on so we can work through your information.
Yeah, I think we can hold on to after in the midpoint somewhere again for more questions. So we'll go into trade secret, which one of the question arised. And so what is a trade secret, right? What qualifies as a trade secret? Basically, it protects information that has value because nobody knows it. So like the famous example is Coca-Cola. Another one would be KFC. So the recipe of Coca-Cola, nobody knows it except few people at Coca-Cola. And it has value because nobody knows how to make a Coca-Cola formula. So, and obviously we have other soft drink brands like Pepsi, RC, Cola, etc. And they taste different than Coca-Cola. So that's how trade secret is. It's basically you keep it secret and it's not known to anyone. Same goes with KFC. KFC also has their blended herbs recipe for the chicken, which is also kept as secret. Nobody knows it except few people within that company. The other simple thing could be, it could be your company's client list. That can also be kept secret. You don't want to expose their phone number, contacts. That's also trade secret. So how to keep it secret and not to lose it, right? So we know that it has to be an information that has value because nobody else knows it. And it has value because they cannot legitimately obtain it. Also, there is no way to reverse engineer it, as we don't know the information, such as the tricky Coca-Cola formula can be reverse engineered. Again, search algorithms for Google is also a trade secret. We don't know. So hopefully this will clarify something for the person who had the question regarding trade secret. And obviously trade secret, there is no federal agency where you can file for it. It's only patents, trademarks, copyrights. That's it. So our next topic is copyrights. And what is copyright, right? Basically, copyright is a legal protection for authors of original works of authorship that includes literally dramatic, musical, artistic, or any certain intellectual work that is fixed on a tangible form of expression. So we are talking about songs, movies, books, sculptures, painting, etc. You can only protect this expression of that idea once it affixed to a medium that is tangible form, right? So copyright protection lasts for 70 years after the death of the author, if it is an individual copyright owner, and 120 years if it is a business that is the owner of that copyright. So here are some examples as we talked about. It could be literary work like software code, musical work that could be a lyric of a song, dramatic work that could be a musical composition in form of a sheet music, pictorial graphics, sculpture works, motion pictures, architectural work. So, and basically, you'll find this copyright notice for most of on their company's website too. And copyright basically is recorded in Library of Congress, not at the USPTO here. And so the next topic we have is patents. So what is a patent, right? A US patent is a property right granted by United States government to an inventor. Basically, this gives the right to exclude others from making, using, offering for sale, or selling the invention throughout the US, or importing the invention into the US for a duration of your patent term. It is territorial. There is no such thing called worldwide patent. Again, here the government grants a property right in exchange for the public disclosure of your invention, just like the quid pro quo, right? You file for that application, your invention with the public disclosure, and in exchange, you are basically sharing that invention to the public. And we'll go over some next slides, how it helps the general public. So we have three types of patents here. One is the utility patent, which is the majority of our patents that we receive. And it basically covers new and useful process, machine, article of manufacture, or composition of matter. That is, it protects the way that something is used or works, right? Then we have the design patent, which protects the way something looks or protects the way an object appears. And then we have the plant patent, which is a new and a distinct invented or discovered or sexually reproduced plant. So here the both utility and plant patent gets 20 years from the date of filing, and the design patents are 15 years from date of issuance or grant. So here we look at the tree map of Arizona's top 15 patent classifications that filed by the inventors within the state of Arizona. You'll see almost 23% of patents, they come from semiconductors. Here you see this, the whole blue section, that's 23%, which makes sense because Phoenix has Intel's plants around here. And we are also having a forthcoming Taiwan semiconductor manufacturing plant that's also coming next year. So that makes sense of semiconductors dominance here. The second topmost is the electrical digital data processing. That's almost 13% of it. And then we have the diagnosis surgery, which is almost 5%, and so forth. The other 13 goes. And here is another chart that shows you the comparison of 3 different types of patents. As you see here, we have almost 12,000 utility patents, which makes sense. From the question, from the survey poll that we saw, then we have almost close to 1,000 design patents and fewer plant patents. So again, how does it benefit the public, right? The idea behind this is to encourage inventors to disclose their invention. Why, right? Because it's, again, like a simple quid pro quo. In exchange for your detailed description of your invention, that includes how to make and use it, an inventor can receive a time-limited exclusive right to practice that invention. And how does that benefit the people? So it basically allows them to incentivize that disclosure by disseminating for the new ideas in society for the societal benefit. Basically, it helps further improve the innovation or make technology advancement by taking the old concept they can improve upon, right? That's the idea behind it too.
Gautam, we have several questions that are building in our Q&A.
Yep.
Are you ready to take a few more?
Sure.
All right. How about I'll give a few. I think Esmeralda and I will kind of tag team on some of these questions.
Sounds good.
All right. So here we go. How can I legally use copyrighted music in the videos I publish online?
Okay, let me go to copyright. So can you repeat now that question again, please?
Sure. How can I legally use copyrighted music in the videos I publish online?
So if you publish it, I think I'm not that sure about it, but I think the way we can do is, as I said, you can record copyrights in the Library of Congress, because we as patent office do not handle copyrights. So I'm not too expert on this topic.
I'm happy to jump in really quick. I won't say that I'm an expert either, but I know with copyrighted music, typically you would need to have a license in order to use that music from someone else. And I know that there are a number of different, I'll say, music licensing companies in the US that own albums of licenses. And so you would likely need to contact one of those companies to try to purchase a license to use the copyrighted music.
Oh, thanks, Janelle.
Yeah, and someone else had another question. I know Library of Congress has a registration process for images, so maybe that's more appropriate. So
Right.
Library of Congress. Okay. All right. Let's see. Can international businesses based outside of the US file an IP in the US? What are the advantages and disadvantages?
So it depends. They can definitely file in USPTO. We do see a lot of foreign utility patent applications that are filed from Japan, Asia, all around the world, Europe. So if you think that your product is going to be consumed in United States, it's wise to file for patent in this country. If you think you want to use that product in Europe, you want to file your application there too.
Here's one on trademarks. Where can we go to see sampled trademarks registered with the USPTO?
So USPTO has a trademark called TESS, which is a search. You can go type in, let's say, a trademark for Apple. I'll just say you. Maybe I can quickly show it also. If you. Oh, you can go from the USPTO's main website here. That's a better way to show it. Let me quickly. So if you go in trademark here, you will find a bunch of resources searching for trademark. If you click on it, and then you'll search our trademark database, which is called TESS. And here is the best way to look for basic. You can check live or dead, and you can find anything. So let's say we'll just type in Apple. So you'll see a bunch of it. And now you just have to filter it by, what you're looking into, by class also, as I said. So hope that helps how to look for trademarks. But again, if you want to know more depth about trademark, as I said, I would highly encourage to participate in the trademark event that happens.
All right, should we take a couple more?
Sure.
Okay. Hi, I'm specifically interested in using trade secrets in my business. I've developed custom hardware processes that could be sensitive in regards to national security. Do you have recommendations about how to raise money from investors or raise initial interest from DoD contract customers when our technology is trade secret protected? Any trade secret info is much appreciated.
So trade secret, as I said, you don't want to give information to anybody unless you sign some kind of an agreement between whatever parties to protect that, this is confidential or whatever. So I think a lot of people, I think, use non-disclosure agreements, but I'm not sure how can that protect the trade secret. Just as I mentioned, the two examples, Coca-Cola and KFC, those companies, they haven't, those are kept secret. They are not known to anybody. So I think trade secret, it's a very tricky. Just the algorithm for Google also, that's also a trade secret, right? We never say, let's go Bing it. Nobody does it. We say, Google it. So that Google search is a trade secret. Nobody knows it. How to approach DoD on it? I'm not sure I can answer that, or advice on that. You can definitely find a legal counsel on that aspect to see. And obviously you don't want to disclose your secret that whenever you talk to anybody too on that.
Here's one, Gautam, on describe specifics of software. Oops, it just jumped away. Describe specifics of software process patents.
So software patents, in my business method, I do see a lot of software patents. So let's say Uber app, right? When Uber came out with how to pick up the one consumer and drop it at location, that whole software is a software, but it has been implemented on a pretty tangible form, right? That software process is implemented on transportation aspect of it, and there are patents on that. So you could have a software, and then there are a bunch of other variety of laws that apply. So you have to be careful on that. And I think, again, USPTO.gov is a great resource to get more understanding in depth on that.
So let's take one more and then maybe we turn
Sure.
it back over to you. We want to make sure that we have enough time for you to finish your great material and Janelle as well with the resources. So here's one more question. During a trademark application, can you decide to apply for a trade dress instead of a trademark? Also, can you provide some examples of SOF service mark? Examples of a service mark, sorry.
Okay. So I think you will see SM written on service. So basically what I mentioned is service marks are basically a source of service, right? I can't think of my mind right now any kind of service, trying to think what kind of service that has a service mark right now.
What about for a hotel or like United Airlines, American Airlines? I think Hilton, American Express. So those are all different services.
That's true. Yes. So you will see the logos. Thanks, Janelle, for helping out with that. Yes. So those are the service mark where you're providing some kind of services. And those are basically trademarks. So as I said,
Okay.
Yep.
All right, let's go ahead and continue back to the presentation, Gautam. You've got the
Okay,
floor again.
perfect.
We'll keep the questions coming. There are lots in there, so we'll
Okay,
get to as
great.
many as we possibly can.
So I think we talked about this slide and we're gonna go. So when should you file for a patent application, right? So you must file for patent application within 1 year of your first public use or disclosure of your invention. This means that you must determine the first offer or sale date or first public disclosure date. Because United States now operates as a first to file country, it is important to file for your patent protection as soon as possible. And the other best way to protect your disclosure is just file for a provisional patent application. It's the low cost way of putting down your idea and filing into the US system. So from the time you file for provisional application, you have a year's time frame to basically perfect your invention and file for non-provisional application. And we'll go over the fees in the next few slides. We'll have that. But that's the best way to basically, start with your filing of patent application. And so what are the risks of the disclosure, right? So basically, as I said, if you have an idea, how do you protect it for your invention? You definitely do not want to, if you publicly disclose your invention before you file, that can cause you to lose your patent filing rights. So basically, that can be used as a prior art against your own invention because you did not file it in the US Patent Office to set up the date. So we would highly encourage people, if they have something, the best low cost way is to go file with a provisional application and then perfect it within a year to file for non-provisional. Again, disclosures, crowdfunding campaigns, like where you are looking for a fund, just like the Shark Tank, as I said, if you have an idea, you go and present it to them and you don't have anything filed, that's the best way to lose your invention. Another thing is posting your invention on internet, like, making a presentation slide of what you want to do or presenting to potential clients. Newspaper or journal articles. Those are some examples of public disclosure that you want to protect yourself. And so here are the filing fees. As I mentioned about the provisional filing fee that you see up here. For the large entity, it's around $300. A small entity, it's $120. And for micro entity, it's $60. So micro entity receives almost 60% discounted fees for all the fees you see. And small entities receive almost 60% of discounted fees. So the initial cost of filing your patent application would be $1,800 for large entity to $364 for a micro entity. And so here are the discounts available on the fees if you qualify for smaller micro entity requirement, right? As I mentioned, micro entity receives almost 80% of discount, and there is a threshold for a gross income that is around $212,000 as of September of 2022 to not exceed to qualify for that micro entity status. And then the small entity status, you are a small business with less than 500 employees or a nonprofit organization can also be qualified as a small entity status here. So hope that answers, we finished the topics on the intellectual property. we'll go over the USPTO resources that are available for the public.
One question before we switch
Sure.
over. What is intent to use applications?
Is this related to trademarks?
Oh, that was the question. I am not sure. It was John. John, if you want to unmute and give a little bit more clarification, feel free. All right, or you can add just another
So I
question
think
or put it in the
my,
chat. but-
my guess is he's talking in related to trademarks. So intent to use is like when you know that you're gonna do it, but you just don't know where your goods or services are getting classified. That's when you go with the T standard application fee, which was around $350, that you file your application with what you are planning to use it for, and we can determine where it will classify, and then we'll build up on that.
Okay, thank you. All
Yeah.
right, Janelle, let's switch over and let's learn about the resources that are available.
So before we jump to Janelle, let me show a couple slides before we hit her section.
Sure,
quickly.
go ahead,
Yep.
Gautam. Thank you.
Okay, so we got the USPTO's free services here. I'm gonna quickly go over it and show it to you guys where it is available on the website. If you type uspto.gov, you will see the access our free services here. And you can basically filter those services. Let's say you want to just do trademarks, you click on trademarks, it's going to tell you application assistance. It will also guide you through business resources here. And it will also tell you what education trainings we are having. So you can filter using this access our free services. I'm going to keep it short on this. And then we also have our staff data, USPTO's data here. We are based out of Alexandria, Virginia. And you can see that last year in 2022, we had almost 646,000 applications filed, and we had patent issued almost more than 50%. Same with the trademarks here. We had 787,000 trademarks filed by class, and certificates of registration were issued almost 450 of them. And we also have our regional offices, one in Detroit, one in Denver, one in Silicon Valley, and one in Dallas. And then we have additional resources. That is the Inventors Assistance Center. So here it is available for public. This inventor assistance program basically staffed by former supervisory patent examiners and experienced former primary examiners like us, who can basically answer general questions regarding patent examination policies. And they can also basically give you, help you with basically what forms are needed to file for patents. And then we also have our patent pro bono programs here. This basically allows inventors and small business to meet certain thresholds, and they are eligible for free legal service assistance for preparing and filing for a patent application. This program connects you with an attorney that are willing to do the pro bono work, basically. And then we have the pro bono program organizations. If you go on this Arizona Public Patent Program .arizona.edu, you would be able to find that there. And we also offer law school clinic certification program, where almost 60 law school clinics participate into this pro bono public. Here, the students can help individual inventors and entrepreneurs to file for, help with filing with the patents or trademarks, whatever the IP you guys choose. And here's the PTRC in Arizona, where Janelle is gonna kind of go over this. Thank you very much.
Thank you so much, Gautam. Perfect. I'm going to go ahead and share my screen. One moment. All right. Hopefully everyone can see my landing page here.
Yes, we do.
Great. Thank you so much, Paula. So as Paula mentioned earlier, I'm Janelle Breedveld. I'm the Assistant Administrator at the State of Arizona Research Library, and I am also the Patent and Trademark Resource Center representative here. So I know you've just heard a lot of really helpful information, but I just wanted to briefly share a little bit more about the Patent and Trademark Resource Center, or PTRC. So PTRCs have been around for a long time and they're found nationwide. And really the goal of PTRCs is to provide a local resource that can help disseminate information about patents and trademarks and also support intellectual property needs. So PTRC representatives like myself were trained on USPTO resources and databases. And then that way we can be, again, a local resource here to help you figure out what you might need to know. So here are some fun photos from our PTRC grand opening back in 2013. This was at the Capitol building here in Phoenix. And now our PTRC has moved. We are located in the Polly Rosenbaum Archives and History building. And then I just wanted to flag, we are the only PTRC here in Arizona. So I keep saying the word PTRC. What does that mean? What can we really do for you? So here on the slide, I've highlighted a few different things, but just to break these down. So first, we can answer questions. You just heard a very informative presentation that really broke down kind of the distinctions between different forms of intellectual property. But if you leave today and you still have questions, our PTRC is also here as a local resource, and we can give you some more clarification if needed. Demonstrate searches. So we have found, this started during the pandemic, and it's something that we have continued, that it's really convenient and effective for us to schedule Zoom meetings where we can share our screens, we can show you how to find USPTO databases, and also how to create specific searches and view the results. So I do want to highlight, we cannot conduct a patent or trademark search for you, but we can demonstrate how to create your own search. And we also always use generic examples. The goal of that is we know that you have these really unique ideas, but we don't want you to disclose the details to us. So that said, let's say you're doing some historical research or you're just curious. If you come to us with a specific patent number or the name of an inventor, we're happy to pull that information and we can share copies of their patents with you if needed, or we can also help demonstrate how to find specific things like that yourself in the future if you're interested. So as I previously mentioned, we're glad that you have ideas, but for your own intellectual property protection, it's best that we don't hear about them. So I'm a librarian, I'm not a lawyer, and I can't advise you on how patentable something is or whether or not you might be infringing on someone's trademark. But what I can do is I can direct you to some of those pro bono services or law school clinic services here in Arizona. Some of those are at the University of Arizona and also Arizona State University, and they may be able to take on your case, connect you with a lawyer, and the lawyer can provide you with the specific guidance you need. I also can't recommend specific lawyers, but there are certain local directories that I can point you to so you can make some informed decisions. Lastly, location. So our PTRC is the right place for a lot of questions, but some things are going to be outside the realm of our expertise. One example is we've heard a lot about registering a trademark federally with the USPTO, but you can also register a trademark here in the state of Arizona, and that would be something that you would do with our agency partners at Business Services in the Arizona Secretary of State's office. They handle that state level trademark registration. So if you contacted us with any questions about state level registration, I would be referring you to their office for more information. Just a few more quick things. So I wanted to highlight that our PTRC has 2 research guides. These have links, a lot of resources that you've already seen today, and more that are about the process of patent and trademark research. And since those 2 intellectual property paths are pretty distinct, we have one separate research guide for patents and one separate research guide for trademarks. And in addition to looking at the USPTO's website, we certainly recommend reviewing these guides if you're looking for more information about intellectual property, and if you're also interested in more local resources here in Arizona. Now, really quickly, I just wanted to highlight, so USPTO launched their web-based patent search tool called Patent Public Search. It's also been called PPUBs last year. And this was something that was really exciting because it meant that researchers could search for patents in the comfort of your own home, as long as you have a computer device and an internet connection. So if you haven't looked at this site and you're interested in exploring patents or a patent application, I definitely recommend that you check out this tool. Here on the screen, you can see that USPTO has provided some great training materials, but also here at the PTRC, if you have questions or if you need help using Patent Public Search, again, you could contact us for one of those Zoom consultations and I could show you how to use the site. And that takes us directly into the best way to contact us for help from the PTRC, or if you're interested in getting added to our email distribution list for any future PTRC programs that we may be putting on, is through our website. And you can see the link that's there on the screen. That will take you directly to a web form where you can fill out any questions that you might have. You can also go to our website, which is azlibrary.gov, and you'll see a big green Ask a Question button on the landing page. You can also click that. You'll get the same web form and just let us know what you need. So we're happy to help answer questions or point you in the right direction where you can get the assistance that you need. So that's it for what I wanted to share. I know I was short and I tried to keep it quick so that we have time to answer more questions, but thank you so much for making the time and joining us today. And I'll go ahead and stop sharing and say, Esmeralda and Paula, what other questions are there in the Q&A for us?
Right, so Esmeralda will take the next round of questions. We do have several.
Yes, we have quite a bit of questions here.
And
All
I'm going to quickly post share my slide for the upcoming events quickly too. So it's on the side unless somebody's sharing something. But here are our upcoming events that I wanted to share too. We have tomorrow Pad to Patent Part 1 IP Basics. And then we have the Trademark Basic Bootcamp Module 2. The Module 1 was yesterday. Then we have the Pad to Patent. So you guys can go and register through the USPTO.gov events page. Again, this is the best way to get knowledge of what you guys want to do. So I'll leave this page so you guys can have an idea.
Yes, go ahead and leave that up while we take questions. That's
Sure.
great. Go ahead, Esmeralda.
All right. So if someone else adds .com to your name and registers it, are you protected by law?
Somebody puts it. Well, so whoever puts that .com in front of whatever the trademark, I'm guessing they have a trademark file for it without, like just google.com, right? Simple example. So Google has a trademark on the name word itself, Google, and they have their website, google.com. But again, I'm not the trademark specialist here, but the trademark basic boot camps are amazing for all more into deeper understanding of those topics.
How do I determine my trademark is not in conflict with another too similar trademark?
So as I demonstrated earlier, that you could basically go in TESS, which is the trademark search available to public where you can type that trademark that you have, and you could basically do initial search. This is a great way to basically do your own research before you hire or approach any legal counsel. And if you miss that test, I can show, if you have time down the line, again, how to get to the trademark search.
All right, awesome. Thank you. All right, next question. I write parodies to be used in film. How do I determine if I can have changed the lyrics sufficiently from the original song to be considered a parody?
That's again, it's a copyright question. I think, as I mentioned, you could basically, if you have a parody, I think the best way is to look into Library of Congress, or as Janelle had mentioned before too, that you can find local, within that area, any distributors or musicians that can help with that. Janelle, do you have anything to add on that?
Nope, I was going to chime in and say same thing. I know sadly there's a lot of great copyright questions coming through, and as we've mentioned, USPTO, that's not our primary area, but for most of these questions, going to the copyright website through the Library of Congress, they have a really helpful FAQ page and similar contact us information. So that's going to be a great place to go for those types of questions.
Right. Next question. If we are selling professional services like writing and photography, how may I protect my work if clients who hired me are not paying as agreed?
Ooh. I think I don't know if we can give you legal advice on that.
All right, I'll go to the next question then. If I patent in the US only, does that limit myself to people only in the United States?
Yes, you do. So you can, let's say if you patent in the US and let's say you're going to use that product somewhere else, other parts of the world, it's pretty wise to apply applications there too simultaneously when you're doing, because you have a 1 year's time frame. Because that based on different countries and laws, that prior art or disclosure that you have can be used as a prior art against you too.
All right, thank you. Next question is, what IP is available for software applications? Does the application source code need to be available to file for protection?
So again, software code, you can definitely file for it, but as I said, it has to be formulated into tangible form, because there are multiple laws that's gonna there's a law called 101. It's called abstract ideas. You just have an abstract idea where it's an idea, but it is not benefiting or kind of basically affixed to a tangible form. It's going to be a tough challenge. So that software code has to do something, like it has to basically improve the computing part of it, or it has to, as I said, into a tangible form somehow help out. But again, that one law called USC 101, 35 USC 101, you can look into that, and that will give you a good idea of what's protected. But again, our Path to Patent series, which starts tomorrow, IP Basic, will cover more in depth about a lot of this. That's a great way to learn more on Path to Patents.
All right, next question. Once a provisional patent application has expired, is it possible to resubmit the application again with elements not included in the original application?
So that completely depends what those elements are. If they expired and you had the 20 years to utilize, but you're you can, as I said, you can improve upon, but I can't really suggest that what those elements are unless we see as when we are examining this patent application. But again, that's a question. It's a very
Gautam, I have a question. There are several in here related to international situations. Are there any upcoming trainings that USPTO or resources that might help those folks interested in the intellectual
yes.
property and international situations?
So we do have lot of we have specific one presentation on the international, and let me go to the events page here and I can show you. So if you go view all public events, so we do have, I think, so it's called module 4 application. I think it's module 7 or something that where you learn about international filing and stuff. But this is the web page that, as I mentioned about USPTO.gov events, you'll have a bunch of free registration that you can register for all kind of events.
Okay, now I'm keeping an eye on the clock. I think what we'll do is we'll start to wrap things up. So I will go ahead and share my screen.
Okay.
Thank you everyone for all of the, now can you see my screen? Again, yes, okay. Thank you everyone for all of your questions. As you can tell, this is not necessarily an easy topic, very complicated, a lot of things to learn and know, but there are resources out there from the USPTO and all the ones that Janelle shared with you for the research library to help you on your path of exploring what intellectual property you need. So just turning back over to the SBDC and our services. So there's a lot more to, of course, running your small business than intellectual property, which is absolutely important. But if you need help with any other areas that I kind of previewed as we started our session today, financial review, access to capital, marketing, export, certifications, government contracting, the SBDC here in Arizona, and I know we have those joining us outside of Arizona as well. You'll find SBDCs near you in your state. We're here to help you as small businesses, and it is no fee counseling. And so, and also training like the program today. So please check into our services. It's very easy to, and so you see on the map where we are covered here in the state. But if you are interested in our business counseling services, go to our website, the azsbdc.net, and you can enter where you are located in Arizona and find the SBDC center closest to you. Also on that same website, you'll find our training calendar, and that lists trainings offered across the state. So this one is a webinar, but based on your location, there are going to be other training offerings near you, webinar format, in person. So be sure to check that out as well. If you're outside of Arizona, there again, just do that Google search on the SBDC in your state, and you'll find similar services available to you as well. We will be sharing the recording again and the copies, the PDF versions of the presentations. So you'll be able to refer back to that. In the follow-up email that Esmeralda will be sending out, we'll include a couple other quick links so you can actually get to some of those resources very quickly. If you're a client of SBDC, reach out to your counselor because they can point you in the direction of those resources as well. And with that, I would like to thank everyone for joining today. We will be sending out a survey. Esmeralda, do you just want to wrap us up and tell about the survey and the follow-up email communications that you'll be sending?
Yeah, so I'll be sending out that email either today or tomorrow, and it'll be containing the recording to this webinar as well as the information that Gautam and Janelle have provided for us. And you'll be receiving a client training survey tomorrow. via email. So if you could please answer that, that'll help us be able to provide future training for you all. Thank
All
you
right.
all.
Thank you. That concludes our webinar, Janelle and Gautam. Thank you so much for your time and sharing all of your expertise with everyone today. Very much appreciated.
Thank you very much, everybody.
right.
Thanks for joining.
Thanks for having us. Have a great day, everyone.
All right.
Thank
Bye
you
now.
all.
Take care. Bye.